Electoral Board to order. Please stand for the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, nation under God, indivisible, with liberty and justice for all. All right, we do have a quorum. New business. Everybody should have the, does everybody have the rules of procedure that were passed out?
You got an extra copy for some reason.
Should have three.
I emailed those to you a couple of days ago. Yeah, for some reason.
I can give you mine.
I bet they look a lot like other rules of procedure.
No, it's okay.
Any questions or concerns on the rules, procedures, I should say? All right, then I will entertain a motion to approve the procedures as presented.
I'll make a motion.
I'll second.
Roll call, vote, please.
Mr. Reed?
Aye.
Mr. Magnuson?
Aye.
Ms. Vespa? Aye. Motion passed 3-0.
All right. We're here today regarding a hearing of the objection of certain nominating petitions, a paper submitted by a candidate for election of office to village trustees for the consolidated election on April 6, 2021. There are two objections filed by Ms. Barbara Magnabosco. Counselor, Mr. Schuster, do you have any?
Yes, good evening, Mr. President. So there are two objections. We have numbered them EB 2021-1 and -2. Present for the objector is Attorney Kenneth Shepro, who has filed an appearance with the village clerk. We have a couple of folks in the audience. They've signed a sign-in sheet. It's about 4 minutes after 5, and I do not see the candidate in the building yet. So he has been notified of the meeting. He picked up that notice, right? And
Sure.
signed a receipt for
Yeah, I
it.
got the
Village
receipt.
Hall.
I got the receipts.
All right. You get a return of service from the sheriff.
Yeah.
So you may indulge in a few minutes, I don't know. Then the next order of business. I do want to ask the objector, you intend to hear these separately, or would you be asking to consolidate?
I would defer to learned counsel as to what you think is the most efficient way of doing that. They obviously are interrelated.
I mean, it seems like
It
the
seems like-
witnesses that you may have are gonna talk about the same thing,
It
correct?
could be, they might talk about different aspects, but I think it would make sense to consolidate them. And if you are asking for a motion, I would move that the board agree to consolidate them for a hearing and decision if appropriate.
Okay.
So, who's that motion?
Yeah, I will entertain a motion to consolidate both objections.
For purposes of the hearing. Obviously, the decision, you're gonna, if it comes to that and the candidate appears, discussion be about all or each of the various issues raised in the two objections. And we'll talk about those separately, but for purposes of hearing any evidence, I think you could hear it together. So is there a motion?
I'll make your motion to consolidate for the cause of the hearing only.
I second.
Any questions or comments? Roll call, please.
Mr. Magnuson?
Aye.
Mr. Reed?
Aye.
Ms. Vespa? Aye. Motion passed 3-0.
What is the appropriate amount of time to allow this young man to make an appearance?
A little bit, I suppose, if there's some issue with the link or something.
Just remember 30 minutes for the professor.
What's that?
I just remember 30 minutes for a full professor from college.
About half that, 15 minutes?
Well,
All right, well.
has anybody heard from him?
I don't know the young man.
He did not reach out to me at any time prior to the.
What happens if he doesn't show?
You might enter an order against him by default. You might do something else. We'll see what the objector proposes.
Are we allowed to ask why the objector's not here?
Well, the objector is here by our attorney. We could take that up, I guess, if we're going to proceed further.
I just refer you to Rule 2A.
Maybe he's memorized yet.
Yeah.
After 5.
Did you guys?
They said he's now showing 10 after 5.
10 after 5:15. And
He's one.
I don't know, it's kind of clear today.
I was gonna get to quarter after, then call it a day.
I know I've had trouble with, not here, but also somewhere else, getting the link right and scrambling around on the phone to figure out how to get in if we're going to attend remotely. So, a few minutes.
Yes, we've had trouble with that too.
I think the 5:15 sounds reasonable.
The board meeting doesn't start till 7, so I guess we got plenty of time.
chicken wings?
No, I
Eat them all.
eat 10 little ones,
How many?
10 little ones, little baby ones. Those are good. Oh, they look good too. Huh?
Make some for Peter too?
No, he'll need them.
No?
No, he's not doing keto. They're so easy to make.
Very easy.
They're all big in school.
Only really things in the bottom.
All right, 15 minutes are up. That would suggest that,
Mr. Shepro?
At this point, Mr. Chairman, I would respectfully ask that the respondent be declared in default for failure to appear. I believe it will reflect that he was served, picked up papers, was aware of the hearing date, and has not made any appearance nor apparently contacted the board with respect to same. And I would respectfully ask, therefore, that the objector's petition be granted and that Mr. Morales' name be stricken from the ballot in both cases.
So the law seems to allow this. If you find it on the objector's petition on its face, okay, without hearing evidence, so on its face, if you took as true what is set forth in those petitions, though that would be sufficient to invalidate the candidate's nomination papers, then you can make a finding, certainly he's in default for failure to appear, and then you can make a ruling to strike his name from the ballot and declare his petitions invalid.
What if there are concerns about the objection? On its, as you say, on its face.
Well, the rule is if it's in court, we would say you take as true what's stated there because there's no contrary evidence. if you have a concern about any one of them, there's a total of five, I believe, five different statements of objection. You wanted to pick one that you're, or more, that you would rely on as, for purposes of your order, you could address it that way and see if the rest of the board went along with that. But again, since there's no one here to contest what's stated in the objection, the process calls for you then to take that as true, take what is stated there as true against him. And there are a number of different objections raised.
I have an issue personally with the signature requirement that's stated in the objections. It references the wrong year. And so, I mean, if we were supposed to take it as face value and doing research into the Illinois election code, being with the fact that it states the wrong year, again, I understand he's not here.
Well, but you would say on its face, if you take that as true, it's not a valid objection because it's reciting the wrong year. It's reciting the wrong requirement for total signatures.
Correct.
Is what, so I think you're entitled to do that. You don't have to change the objection in order to sustain it, but if you find that on its face, that would not be a valid objection, that's a fair approach to the question in front of us.
Although, would I be correct that if that is the board's intention, I could still present evidence on that point?
If you wanted.
It's up to the rest of the board. I'm one of three.
Right, well, not having Mr. Morales show up for his own hearing, I think, there's more than just the date that is incorrect, the striking of the signatures, the submitting of paperwork. And without him here to answer questions, I don't know how we cannot find by order of default that he should not be on the ballot. Anyway, everybody else showed up for this hearing.
Yeah.
To give this gentleman his day in court, if you will. And he didn't show up, so. I think.
Well, striking one signature maybe doesn't affect the question.
Right, no, I agree.
Anyway, but I guess the question is then, Mr. Shepherd, is there some evidence you want to present?
On that issue? On the issue of the signature requirement?
It's up to the rest of the board.
Well, I know, but before you make a motion and a finding, then it's kind of too late.
But I didn't make a motion.
I understand, but you raised the question
Okay.
and the objector's attorney is asking to be able to address.
Well, I guess I would reserve whether I present any evidence if the board is going to take action on the default issue first.
All right.
The chairman's already stated, and it's obvious that the candidate's not here. So it's a one-sided argument at best.
Yeah.
But at the end of the day, reading over the objections, I have problems with some of the objections, but at the end of the day, he's not here. So it's a one-sided argument at best,
Right.
because there's nothing that we can do without the other side.
Without Mr. Morales answering the questions, I don't.
No, it's true.
Yeah, there's legitimately nothing we can do without him being.
Right. Exactly.
And that's the position you find yourself in.
So.
So we have a motion to find Mr. Roberto Morales in default for failure to appear for this hearing. Take it in steps.
I will entertain a motion to find Mr. Roberto Morales in default for not showing up for his hearing.
I move.
One second.
Any questions or comments?
Just note it's now 5:20 PM and he's still not here.
Roll call, please.
Mr. Magnuson,
Aye.
Mr. Reed,
Aye.
Ms. Vasquez, aye. Motion passed 3-0.
And the next motion would be to sustain the objections in the two petitions that have been filed, or to sustain some of those objections, but not all of them, as you may choose to act.
At this point, probably easier just to sustain all the objections. I'll entertain a motion to abstain the objections in case EB 21-1 and EB 21-2.
I make that motion.
Okay,
I make a motion.
I made it.
She makes, I thought you were asking for it to,
Yeah.
Ms. Vasquez made the motion.
Do I have a second?
You're more than welcome to.
What's that?
You can.
You could.
I'll second
Someone
that.
else does.
Any questions or comments? Roll call.
Ms. Vasquez, aye. Mr. Magnuson,
Aye.
Mr. Reed,
No.
motion passed 2-1.
Any public comments?
Well, I'll have to prepare a written order to that effect. It will have to be approved by you and signed, and,
Approved by this board, you saying?
yes,
So we have to meet again?
we have to meet again.
Could I respectfully ask that the appearance of the objector be waived at the reconvened hearing if it's just for purposes of entering the order?
Sure, you can ask, does the board have an objection to that?
Well, if he gets stuck in traffic or something, we just ruled on him, but, I mean, he should be here.
No,
I'm with you.
Mr. Shepro is saying that he will not return. We're gonna have to recess this meeting and if we sit down for a minute, approve the findings of fact, the decision, and sign it. It'll be a very, very short meeting, but one that you need to, it's the final step. Mr. Shepro would love to come back here that evening, but he's willing to miss that event. You don't object.
All right, I understand now.
All right. And when that recess meeting then occurs, then after that promptly it has to be served on Mr. Morales, and he has rights to appeal. Should he feel that that's something that he could do. So I'll
And I
have it
believe-
ready shortly.
We're just gonna recess this meeting and then.
You know what? Why don't I prepare it before I leave? You're all coming back here at 7:00.
Right.
Why don't we just recess till 6:55 or 6:50?
6:50 and.
And I'll get it ready. It's not, I've got my computer right here, so.
Okay,
Okay,
All right.
any public comment?
thank you
Are
for
you
your.
supposed to have public comments prior to the beginning of the meeting?
No,
No.
you can public comment at any time. And on this agenda, it's at the end.
An editorial comment, the notion of public comment at an electoral hearing is kind of absurd, but that's the way they wrote it.
Every public meeting,
Yeah,
so.
All right, so we will recess this meeting until about 6:55.